Adjudication module. Before we begin, please be advised the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. Let's first go over what these two motions are. A motion for summary judgment is a court order ruling that no factual issues remain to be tried and therefore a cause of action or all causes of action in a complaint can be decided upon certain facts without trial. A summary judgment is based upon a motion by one of these parties that contends that all necessary factual issues are settled or are so one-sided they need not be tried. The motion is supported by declarations under oath, excerpts from the depositions which are under oath, admissions of fact, and other discovery, as well as legal argument that argue that there are no triable issues of fact and that the settled facts require summary judgment for the moving party. A motion for summary adjudication is a court order ruling that certain factual issues are already determined prior to trial. This summary adjudication is based upon a motion by one of the parties contending that these issues are settled and need not be tried. The motion is supported by declarations under oath, excerpts from depositions which are under oath, admissions of fact by the opposing party, and other discovery as well as legal argument. Where you'll find the opportunity to use a motion for summary judgment or adjudication is during the discovery process. You may find yourself with enough material facts to support and the option to resolve the case in your favor before it goes to trial to prove there is no merit for the opposing party's claim. The purpose of these motions is to halt your case before it goes to trial and bring material facts to the judge for them to review in hopes that the case or portions of the case will be dismissed. We want to do this to save your client and you time and money. Now, in order to file a successful motion for summary judgment or adjudication, you will first need the following documents. Number 1, a notice of motion by the moving party or asking party for summary judgment or adjudication. Number 2, a statement of undisputed material facts to support the motions. Number 3, a memorandum that supports the motions. Number 4, evidence that supports the motion. Number 5, request for judicial notice that supports the motion. Number 6, a separate statement in support of the motion, which will include statements of undisputed material facts and must separately identify each cause of action, claim for damages, issue of duty, or affirmative defenses that is the subject of the motion. Documentary evidence in support of the motion. Now your timeline. You will need to file the motion for summary judgment or adjudication at least 60 days after the general appearance or proceeding and no less than 75 days prior to hearing if the motion is served by mail. The motion is to be heard no more than 30 days before trial. The motions will need to be made as a declaration under oath and will be served to all parties and filed with the court. Templates are provided at the bottom of the page to serve as examples of what a motion for summary judgment or adjudication looks like. And as a reminder, the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney.